that's the issue in this case. I mean, the substantive, the reason why the Federal Circuit erred is clearly doctrinal, which is this Court has said over and over again that burdens of proof, like standards of proof, are substantive. They inhere in the substantive right. And the Court has also said repeatedly that the declaratory judgment action is procedural only and doesn't change substantive rights. But I think if you go to the policy question, Justice Alito, reversing the burden in a declaratory action would impair the purpose and utility of the Declaratory Judgment Act, which was enacted to provide a mechanism for determining how the equivalent coercive action would be resolved without requiring the declaratory judgment plaintiff to subject itself to retrospective liability. And indeed, shifting the burden would threaten the issue preclusive effect of the declaratory judgment. Frustrating.
It seems to me we can — all that may be true, but we need to cut down to the basic issue, which is MedImmune changes all that. The idea is you're moving along with the license, everybody's happy, all of a sudden you jump into court. Why shouldn't you have the burden as the party who seeks to disturb the status quo?
Well, the reason, Mr. Chief Justice, is the reason that the burden of proof is substantive and a declaratory judgment action under the Act is aimed not to change any substantive rights. And that's why all of the decided cases in this area, except for the one below, left the burden exactly where substantive patent law left it.
The government agrees that using the same burden of proof that would apply in the hypothetical coercive action that underlies the Declaratory Judgment Act is the best thing to do in this mirror image declaratory judgment action that best serves the purposes of the Declaratory Judgment Act and allows for final resolution of the types of controversies that this Court contemplated in MedImmune. If I could turn to Justice Kagan's point about an incident in which the parties had actually agreed to whether certain products were covered by a particular license, that would be different from the situation we have here because the products in question here weren't actually in existence at the time of the underlying license agreement. The whole point of that aspect of the license agreement was to, as you said, channel future disputes into this particular dispute resolution mechanism.
Are you suggesting that the burden-shifting rule should be different in the hypothetical, Justice Kagan?
I was not about to suggest that, Justice Sotomayor. I was going to say that I think that that would probably be the least logical way to deal with the quandary that might arise from thinking that somebody is then trying to breach the license. We don't think there's any license breach here because there wasn't any prior agreement on the fact that these future products were going to be covered by these patents, that they'd be practicing these patents. But even if there were some concern about the licensee turning around and challenging the agreement that it had previously made, it seems like the problem there is either that they should be stopped by what they already said in the agreement, or Lear needs to be extended to keep them from being stopped in that way. But shifting the burden of proof seems like an odd way to get at solving whatever the quandary there might
be. You have a claim which amounts to a claim that my product does not infringe his patent. The rule that should apply is the person who owns the patent should have to prove that the claims do cover the product. Well, and there are a lot of good reasons, et cetera, that they put in their brief why that should be so. It's easiest for the patentee to know in what respect it violates the claim. Normally, a patent, being a monopoly, should not have too many advantages beyond the scope of the monopoly, and we don't like false patents because that you'd have different results in the same kind of patent with different people depending upon whether in some other instance your client brought a suit or whether this was. I mean, you read the arguments. So looking at those functional arguments, is there any answer that you have to their point other than cases in different subject matters where burdens of proof did shift?
Well, the answer to your question is that the normal default rule is a fundamental tenet, that you can't go into court and say it's the responsibility of the defendant to disprove the allegations of my complaint. In cases where you have a counterclaim, of course, the patentee is going to have the burden of proof. In cases where there can be no counterclaim, you have only one party seeking relief, and that party has the burden of proof. And it follows from the normal default rule, which is the rule of the court, rule of this court. It's the established rule of the land. It's a fundamental tenet that a party cannot come into court.
And the Declaratory Judgment Act doesn't change it. That's your position.